Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
Hey, welcome back to Just Verdicts. I'm your host, Brendan Lupetin, and I love episodes where I get to have people that we've already talked with back on the show again, because that means that they're having continued success. And we also have a new face today. So we previously talked with Carmen Nocera, Ben Cohen on another verdict out in Washington County a few episodes ago. And today we are joined by their superstar lawyer friend, genius, who worked up everything from Jump Street on this case and was the architect of this case. And only because of how many cases she's getting ready for trial wasn't able to try this, Dorothy Dohanics. So Dorothy, I'm glad you could be here with us today.
Thanks for having me.
I'm excited. I'm sick of talking with Carmen and Ben. It's becoming too frequent. But I do remember saying to both Carmen and Ben that I had a feeling I would be talking with them again soon. And here we are with another great verdict in the estate of Jury versus Jefferson Hospital and some other defendant doctors case. Got an awesome verdict, and we're going to deep dive into it today. But since people have already heard all about Carmen and Ben and how they met in law school and everything, Dorothy, can you tell us a little bit about yourself? I've, known you at a prior firm, and obviously been killing it at, Harry Cohen's office. But, tell us about your background.
Sure. I spent about 10 years over at Dallas Hartman's office doing personal injury type work. And I really wanted to focus more on medical malpractice. And so I came over to Harry's office, and it's been wonderful. It's exactly what I've been wanting to do. And I've had, I've really been able to work on some awesome cases over at Harry's office. So that's what I'm doing now. But grew up in this area, went to Duquesne for law school, and that's about it.
Well, in lead up to us just chit-chatting before Carmen and Ben signed on, you were telling me that you're out of town right now at your daughter's tennis tournament. And that led to me learning that you played tennis at Penn State. So, and now you're the coach at where not Central Catholic.
Yeah. So I played tennis over at Penn State for 4 years. And I'm actually the new North Catholic head women's coach. I'm also a volunteer tennis coach over at Duquesne. So I love being around the sport. And so that's where I'm at. I'm in Greensboro, North Carolina, at my daughter's national clay court tournament. So yeah, it's honestly probably my biggest hobby on the side here is just running around to all the different tennis courts in the country.
Do you think, tennis is, obviously there's doubles, but typically it's, 1v1, not unlike sort of trial, where you have to battle and duel your opponent 1v1. Do you think that you've spent a lot of time practicing, competing in tennis, playing Division I? Do you feel like that's lent itself to your work as a trial lawyer?
I think so. I mean, tennis is super competitive. You're on your own, and I think it's very similar to tennis. I come up with a shot. My opponent's going to come with an opposing shot. I got to come up with something better than they can come up with. So it definitely lends itself to the legal world. Really, it does. It's very similar.
I can imagine. So you, as I mentioned at the beginning, and I guess I always tell people there's a lot of luck sometimes on whether you get to be in the trial or whether the trial actually gets to try or not try or settle or so forth, in being part of a verdict. And so if I understand it, in this estate of jury case, you had basically worked it up in large part from filing and the litigation and discovery, and we're supposed to try it, I think maybe with Todd, but you had a conflict with another trial. Can you tell us about that?
Yeah, so I did work the case up, from basically from the intake stage all the way through all the depositions up until mediation. And even Todd and I were planning on trying the case, but then we had another case out of McKean County that was scheduled for about, I don't know, like 10 days later. And so there was an overlap, and we just made the decision to, Ben and Carmen we're going to go do the jury case, and Todd and I were going to go do this other case in McKean. And it just so happened that the McKean County case settled.
Well, why don't you tee up for us, what the case is? And, sometimes cases, the theories and so forth can change a bit over time. You investigated this from the beginning, you filed suit, you pulled the experts together. Tell us about, the case in a nutshell. And did the theory of the case change at all from, before when you're investigating it to how it litigated and what you learned over time?
Sure. So in a nutshell, to keep it short and sweet here, it was a 67-year-old woman who had some difficulty breathing, had some shortness of breath for about 6 months or so. Her pulmonologist decided to do a bronchoscopy, and she went to have that bronchoscopy done. And during that bronchoscopy, the pulmonologist punctured the lung. She went to PACU for several hours after. And during the PACU, her vitals were declining, and she was sent home. And turns out through discovery that there were a lot of hospital policies and procedures that were not followed. The nurses didn't know about, and had any one of these medical providers properly followed the hospital policy that was a good policy, it would have prevented her premature discharge. And so she was discharged. Hours later, about 12 hours or so later, she was found deceased by her 90-some-year-old mother at their home.
Now, Dorothy, when I had heard that the case was possibly going to try, since the courthouse is right next door, and Garrett from my office, and I think Mark wanted to go over and see the openings, see Ben do his thing. We went over there, and for better or worse, I got stuck just listening to the motions in limine arguments. But from what I heard, it sounded like you may have gotten at least one of the physicians or somebody within the hospital system to essentially admit that there was, in fact, a policy violation. Do I remember that correctly?
Yeah, you do. I took probably 4 or 5 nurses' depositions as well as a corporate designee. Just about all of the nurses admitted to the policy violations, and so did the corporate designee. They admitted it. It's very clear. The policy said this. They didn't do that. They admitted it was a violation. And I think, Carmen or Ben can probably tell you a little better what happened at trial, but the corporate designee changed her testimony during trial. So that was interesting. I thought that was really important. We locked in that corporate designee, and she really had nowhere to go other than just completely change her testimony at trial.
So Ben, Carmen, Dorothy, presents you this, beautiful gift of a case on a platter, ready to go. And the two of you, lucky dogs, get to try this great case that Dorothy, sounds like just put a killer job together. So, you get tapped. Dorothy and Todd are going to be tied up. You guys are jumping into the case. Walk us through kind of when you parachute in a month before. What's your process? What's jumping out to you? And then, what are you guys doing as far as strategizing on how you're going to try this case?
Well, I guess I'll start. It was a new circumstance for me to just jump in a case literally right before trial. I know Carmen's had some experience doing that in the past, but usually if it's a case I'm trying, it's one that I filed the complaint on, and I took the depositions, and I was in court and kind of lived and breathed the case for a number of years. And this was a different circumstance. So the first thing I did to really do my best to get a hold of the file outside of just talking to Dorothy and getting the substance as much as I could from her, we record our depositions, just about all of them. So I went through and watched each deposition that we had video of. And I made sure the ones that I didn't, obviously we read through the transcript, but even, Dorothy took very great depositions. I mean, she really did a great job and they were thorough, but they were long, but it really helped me get a grasp on who these people were, what their testimony was, and how they could be presented at trial by really sitting through and watching the entirety of their deposition. So that gave me, I think, a really good sense of who these people were, what they could be testifying to at trial, and what a jury's going to see. So that's what I did to really dive in. And then obviously went through motions and things of that nature, the records, made sure I was familiar with that. But to start, I think that was very important.
And Brendan, like Ben mentioned, my role has kind of been hopping in the trials that I haven't worked up and just preparing it to get ready to go to court. So I start with the pretrial statements and work backwards. I start with ours, start with the defendants, and then I move into depositions. I'll look at some discovery, I'll look at some records, but by and large, I'm looking at deposition transcripts and I'm looking at pretrial statements. I think the one benefit of getting into a trial or getting into a case late in the game is it allows you to sort of cut through the weeds and look at it from a more big picture standpoint. So how do I boil this down as best I can with the limited time that I have and not worry about some of the fluff or get into the weeds on some issues. So pretrial statement and work backwards. And Dorothy mentioned that she played tennis at Penn State. Dorothy broke and set records at Penn State. So I wanted to just make sure that was clear for all the listeners.
You're getting the sense Dorothy's quite humble. But so I agree with you, Carmen, and Ben. I don't know if you have this experience now, having kind of jumped in, having not lived and breathed the case all along. But I've done it both ways, and I think, I've had pros and cons, but I think to Carmen's point of the ability to kind of see the big picture and be able to better simplify it rather than when you live it. Then you have all that, the depositions, the gamesmanship that happened that carries over and a lot of stuff that's maybe sort of irrelevant or you could never really fully get across. Rather than you come in late, you see the case, you get the big picture, you're sort of better able to kind of see it like a juror would, I guess, maybe, has been my experience historically. But Ben, in hindsight, obviously you guys got a great outcome, but as you look back, are you sort of indifferent on which way you would prefer to do it? Or has this opened up your eyes to, just being the trial Rambo that shows up last minute and saves the day?
No, to your point, I think I probably took in more information than I needed. Because really, I wanted to make sure I knew everything. I knew the ins and outs because I wasn't used to coming into a case late like that. And looking back on it, I think there is some value to just making sure, obviously, you're aware of all of the records and the testimony, but this big picture, being able to say, all right, what is the most important parts of this case? And in terms of what I would prefer, I like to be as prepared as possible. And the best way I know to be prepared is by doing everything. So that's just how I learned to do things. It's how I learned to be a lawyer, is to make sure you're doing as much as possible. But, obviously we had a good outcome that we're happy about. So it's not something I'd be averse to down the road. But in terms of what I'd prefer, I like to do it all and be aware of everything, even the irrelevant stuff, because it gives me some sense of security.
So coming in late, last few weeks before trial, what was your approach? You guys then, you do your respective, investigations and immerse yourselves into the case, in your own unique ways. But once you do that and you guys put your heads together, then what was your thought on strategy? Like, how are you framing the case in opening? Is it all about the policy violation? Is there some other big issue that you thought was significant for the jury to understand? And also, in your order of proof, did you guys wind up showing clips, or did you call everybody adversely?
Well, I think strategy-wise, we knew just the way that pre-trial the case got worked up, it was going to be about the policy, because it was such a clear policy that was designed for quite literally this patient. It even, there was part of the policy, she had prior pulmonary issues, and that's essentially what she was there at the hospital to address. She was getting a bronchoscopy. And this policy basically described this exact patient. And it said she must meet X, Y, and Z in order to be discharged. She didn't. We had endless testimony, including from testimony from the head of the PACU from which she was discharged, saying that she didn't meet that criteria. So we knew that was going to be center stage throughout the trial, and we kind of worked around that and made sure that was prevalent throughout. And we knew by the end of the trial that the jury was going to be probably sick of hearing about the policy, but that was going to be kind of front and center stage.
What about the primary defenses? Because, I mean, it sounds like you've got a very strong liability case here. Policy, jurors can latch onto that. They understand policies, and you've got good evidence of violation. Obviously, you're going to trial. I mean, it sounded when I was at the motions in limine argument that there had been settlement discussions. Judge Ignelzi may have even made a reference to that at some point. But nevertheless, you go to trial, there have to be some defenses. And, you're going up against a very formidable defense attorney in Tom Chairs. What were they? What did you think were the biggest concerns from the defense side of things, and how did you address them in opening and then during the trial?
Going into the trial, we kind of knew when you have such a clear violation of a policy, as we did in this case, there's a couple ways to defend that. One is one that we see often in cases where policies are violated, is that policies don't necessarily matter, and policies don't set the standard of care. They're recommendations, they're suggestions. So we knew that we were going to face that, and we did. That even though this was the hospital's policy, that doesn't mean that it necessarily sets the standard of care. And then the other way to attack a policy violation is to say that it doesn't actually apply to this patient. And so what they did is, they take the criteria that is very clearly outlined in the policy and said, well, it's not as clear as it might seem. She actually didn't meet this criteria, and here's why. So they say the policy doesn't matter. Even if it did, she didn't meet it because she didn't meet this criteria. And then finally, the defense that they really pushed hard and aggressively from the beginning. I don't know if you want to even call it a defense, but was just to attack damages. This is a wrongful death case, and the plaintiff is the woman's son. She had 3 kids, but the one son was the plaintiff bringing the case, and they attacked damages from a couple standpoints. One, from her own, the decedent's damages. She said she had all these health problems beforehand. She was there to have a diagnostic test, not a test to treat, not something to treat her. So she had problems before, and this is what happens with old people who have problems. They unfortunately pass away. And then they also attack the wrongful death damages in terms of the relationship between a mother and her children. So that became a big part of the case, was just attacking damages.
How did
in
they,
terms of,
just out of curiosity on that one, sorry to jump in there, but how did they do that? I mean, that seems like that could backfire.
Yeah, Carmen, you want to take that?
Yeah. So the night before closing, I came up with a list of all their defenses. I counted like 12 or 14 things, whether they were outright defenses or suggestions. So one thing that they did was, like Ben said, attack the wrongful death claim. This was a case where we called one of the three sons to testify, and the other two sons, they weren't at trial every day. They were there to support their brother while he testified, and that was the extent of their involvement. There were also some PCP records that the defense took out of context to paint the picture that this family had a strained relationship that they didn't have. They around the pandemic, there was a note that the decedent was telling her PCP that she feels isolated and she doesn't see her kids and grandkids enough. Well, that was while we were locked down. So they tried to take that out of context to paint the picture that they're not devastated by the loss of their 67-year-old mother who died from a routine bronchoscopy. Another thing that they did was they blamed the patient. They blamed her for not coming back to the hospital with the very same symptoms that they sent her home with. So they looked at discharge instructions and they said, well, we told her if it doesn't get better, if it gets worse, come back. Well, the symptoms were the same that she left with. So they tried to blame her for not coming back in, and they threw a lot of stuff at the wall. At one point, they tried to dispute cause of death, which was insane. We'll get into that, I'm sure. But just they threw everything at the wall to see what sticks. And they almost treated it like a criminal case, where you would defend the defendant by throwing everything at the wall, hope to create some reasonable doubt and get an acquittal. So that, to me, that's how it appeared to be defended by a very good defense attorney. I mean, he's very good in the courtroom, but he was dealt a crap hand in trying this case. So he did what he had to do.
Of all the, and I want to talk a minute about, I'd like to hear about Mrs. Jury and the family a little bit to the extent that you can talk about them. But of all the defenses, I mean, Carmen, you're saying, you're counting 12 to 14 by the end of it. Which, of anything, I mean, obviously you guys have a good case, but which defense was the most formidable? And was it, just bigger picture issues, just money's not going to bring back a deceased person, what good's the money going to do? Or were there other ones that you guys collectively were particularly concerned about?
Biggest concern was Darlene not going back to the hospital with symptoms. I might feel differently than Ben and Dorothy do about that. And I think that's just my own, I need to learn to trust the jury that they get it. But I just worried that, hey, you could have a few people who say, well, look, they told her to come back. She didn't come back. That concerned me. Them saying the policies are optional, that wasn't really a concern. I mean, they're in black and white. We had great testimony that Dorothy got, but to blame the patient always worries me because with the wrong jury, they could buy it.
And I think the damages argument from the defense, while it, looking back, didn't land the way they hoped, it was an area of concern because what the lawyer did, what the defense lawyer did in his opening from the outset, he put up our complaint. And when in a complaint, you obviously list, here are the general wrongful death damages, here are the general survival damages, and then throughout the pendency of a case, you figure out which of those actually remain. And what he did, he put that up for the jury to see and just crossed out one by one each of the wrongful death damages. And the only one that was remaining was the loss, of children to their mother, the loss of companionship and services that they get from their mom. And that was the only one that was remaining. And in terms of survival, puts up the survival damages, crosses out one by one. And the only one that is remaining is, conscious pain and suffering. And in Pennsylvania, the conscious pain and suffering is from the time of negligence to the time of death. And in this case, that wasn't a substantial amount of time. She gets discharged from the hospital around 1 p.m. and is found by her mom the next morning. And while she's in some discomfort and pain in that time, this wasn't going to be a case where we talk about here are the days and months that she's in agonizing pain. It wasn't one of those situations. So really, at the end of his opening, he said, here are going to be the two things you have to determine: the relationship between the mother and her sons and the pain and suffering. So I think that really gave us some stuff to think about in terms of what's a jury going to do with this. Even if they find negligence, where are they going to take it?
So regarding now that I understand the time frame from the discharge to the time of death, which is relatively short, but many hours, that would seem to somewhat help the defense of, oh, she had symptoms, she should have returned sooner, right? I mean, because most people, I think, are gonna, well, maybe this is just temporary, it's going to go away. I was just in the hospital, why would I go right back? But was that how you addressed it, or was it more the focus on the symptoms that she had at home that somebody described were the same as what they discharged her home with?
Yes and no. I mean, there was some testimony that she continued to have symptoms. There was some testimony that the symptoms may have gotten a little worse at home. But there was good testimony, I thought, from the one of the defendant doctors, the pulmonologist, who, while he tells the patients, hey, if it doesn't get better, if it gets worse, come back, he doesn't give them a time frame of how long it should take to get better. He isn't specific about, what progression of the symptoms means. He doesn't specify. One of the issues was coughing up blood from a punctured lung. He doesn't specify how much blood is normal, how much to expect, when it should get better. So it was all very vague instructions to her, which I think helped us. But at the same time, they deposed her mother, who said that she had symptoms at home.
Well, how old was the mom at trial? She must have been like 98 or something, right?
94.
Yeah.
Oh, wow. That's and she was with it, lucid, was able to testify pretty consistently. No concerns there.
We didn't call her.
Oh, okay. All right. Well, how did you?
She was deposed and she did great in her deposition, and I think everybody was very impressed by the way she presented. And at the time of trial, she actually had recently lost another family member who I don't forget if it was a niece or someone younger. And then with the trial of her daughter, it was a lot for her. And I think we made we made a decision to not put her through more than what she was already going through. We felt that just being able to present the fact that this notion that this jury, the decedent, was going away, any day now. Just knowing that she had a 90-something-year-old mother who was very with it and lively, kind of the picture of that was enough. We didn't need to parade her into court to testify to say, yeah, I found my daughter dead in her bed.
Yeah.
So that was a decision we made.
So tell me about the story you were able to tell or did tell about Mrs. Jury at trial. Whether it's opening or as the case goes on, I mean, how was she described? What did she mean to the family? What was her lot in life?
Dorothy, you can maybe talk a little bit more about kind of who she was. But I think throughout trial, we echoed the testimony and the story that Dorothy was able to really portray throughout discovery and such.
Honestly, I kept a photo of Darlene Jury on my phone because she was this beautiful, vivacious, active 67-year-old woman. At the time, she lived with her mother. She was kind of recently divorced, but still very friendly with her ex-husband, Ron. She was a dancer. She loved to do jitterbug and different kinds of dances like that. She would travel to go to those different dancing events. Was honestly she was overall very healthy. She had cochlear implants I forget exactly, but many years before this event. But other than that, she was very healthy. She had pneumonia, I want to say like 6 or 7 months before the bronchoscopy. And she just had this lingering, I think it's called walking pneumonia. And she needed this bronchoscopy with biopsy to find out what was that collection going on in her lung, and it needed a certain type of antibiotic, and it would have cleared. So really, she was just beautiful woman, 3 adult boys. She had 2 grandchildren that she was very close with. She was, close with her boys, talked to them, like probably like, how often we speak to our mother, just normal family, very nice. So I don't know if you, Carmen or Ben, want to add anything to that.
We at trial, Brendan, we focused on liability way, 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 way more than damages. We thought that the conduct was so bad that liability would drive damages, especially since some of the defenses were very, had the potential to offend the jury. So and we'll talk about closing, how we kind of framed damages to kind of put a bow on it. But, the most compelling damage testimony was from Darlene's son, Steve, talking about what this loss meant to him, but also what it meant seeing his 2 young daughters losing that relationship with their grandmother. That was very compelling. Plus, we'll talk about what Steve went through during the trial itself. I thought that was compelling damage, not testament, but compelling damage cases as well. So, but liability, I think, drove the verdict.
Well, and that's a recurring, I would say the last, many episodes, that seems to be a recurring theme is, when you have the aggravating facts, the really strong liability facts, that's where the focus of the case, should be these days, contrary to, the old kind of, David Ball thought that at least 50% or more of the case should be focused on damages. I'm hearing over and over from trial lawyers out there, yourselves included right here, about the great verdicts that are developing from, really focusing and staying focused on those aggravating liability facts as the driver, whether it's the tick-off factor or the motivator or whatever you want to call it. But that's just this, echo that I think anybody listening should be thinking about when they're going to trial. But Carmen, tell me about that. I think I know what you're referencing because it was all the talk around, our world. But yeah, what did the son go through and how did that impact, sort of the way the case played out?
So more so than, I'll just cut to the chase. The defense showed an autopsy photo without any warning to Steve. So he had to see an autopsy photo for the first time in trial in front of the jury. And the point that they were trying to prove is still lost on me. But on top of that, what else Steve had to go through during trial was seeing all of the providers who cared for his mom taking zero accountability, them getting up there and saying that these safety policies are optional. And Steve is a safety guy. His job is to make sure that people in the workplace follow safety rules so they can go home to their family at the end of the day. So having that kind of background and then seeing what the defendants are saying and knowing that had they just followed these safety policies, his mom would still be here, that was compelling. Him hearing defendant after defendant change their testimony, that is all a part of the psychological damage I thought that he suffered in having to sit there through trial and hearing that. But the defense showed an autopsy photo during cross-examination of our pulmonologist, and it was shocking. to say the least. It was, I mean, we all knew about the photo because we've had them for years. We never showed the family the photos because there's no reason to. And if you're going to do that, give us a heads up so we could say, Steve, you're going to want to leave the courtroom so you don't have to see this. Or give a heads up so the jurors don't have to see this either because it's jarring for them. Everyone in that courtroom was shocked by the photograph. And like I said, I don't know the point they were trying to make.
Yeah, I had heard, I don't know if it was from one of you guys or maybe it was even from Judge Ignelzi, that there was basically like audible gasps from the jury. You know, your poor client, you know, had to turn away. I think Judge Ignelzi was, you know, repulsed by the sort of surprise of it all and gratuitousness of it from what sounds like a point that to this day remains kind of lost and certainly was not worth the cost to the defense of doing something like that. But, you know, therein lies the magic of trial. You know, obviously a horrible event, but no doubt was a helpful factor to your case. You know, just this collateral thing you couldn't have expected that's going to probably crank up even more, you know, that piss off factor in some of those jurors.
Yeah, I mean, to your point, Brendan, everybody's initial reaction, lawyers, jurors, and the judge, you could hear it, and everybody kind of turned away. And then after the initial reaction, everybody's next reaction was to look at Steve, the plaintiff, and everybody saw him. He literally was covering his head, his face with his hand, so he didn't have to see it. So their initial reaction to seeing that photo and then seeing Steve burying his head so he doesn't have to look at it, I think that really did more than we could have ever argued as to what this is doing to Steve. You know, just seeing that, I think, was enough for the jurors to really get upset. And in talking to some of them after the trial, I think it did that.
Now, did you want to follow up there, Carmen, or?
I mean, we could talk about what a loss means to someone all that we want, but this is a situation where the jury actually got to see with their own eyes what a loss meant to someone in real time. That's powerful, and that's not something that happens in a courtroom.
Dorothy had mentioned earlier that maybe it was the corporate rep or somebody, and maybe Carmen, you had touched on it, that a couple people, that there was either, you know, shades or outright change in testimony at trial. Can you guys talk about that? Like how did that come out? What was the defense trying to do? And how did you point it out?
And the biggest issue in this case was Darlene's baseline oxygen saturation. That was kind of the big dispute here. The policy essentially requires a patient to be sent home the same way they came in. So their oxygen saturation when they leave should be the same as what it was when they came in through the doors. So her oxygen saturation, her baseline when she came in that day, was 97% on room air. That's normal, that's healthy. Whenever she left, she was at 90% on 4 liters of oxygen. So she comes in without oxygen, 97%. They send her home 90% on 4 liters of oxygen. And every witness, with the exception of the doctors, I'd say the nurses and the corporate rep, they testified at their deposition that the baseline was 97% room air. At trial, the corporate rep decided to change that testimony and say that, well, no, her baseline was really 4 liters of oxygen because 2 weeks before the procedure, she was using, 4 liters at home on occasion, which we showed was taken out of context, as you can imagine. So the corporate rep is up there testifying. And for the most part, she is sticking to her trial testimony until I get to the baseline. And I ask her about the baseline, do you agree that it's 97 room air? And she says, no, actually, I don't. I looked at some more records after my deposition that, leads me to believe that I was wrong then. And now, it's totally different. So, and she looked very shameful when she was saying this stuff too. I can't stress that enough. I mean, she won't look at the jury. she looks like it hurts her to change this testimony. And, so I go through the whole impeachment process. You were deposed then, you said this, you're in court now in front of 12 people who are going to decide if you were negligent. Now you say the opposite. And I made a bit of a spectacle about, she had all these documents and records to review before her deposition. Now all of a sudden she changes her testimony and says, well, I looked at some records. So when she walked off the witness stand, it looked like the jurors wanted to start chanting, shame, 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 because it was, so it just wasn't good.
And then Dorothy did a very effective job, in her depo notice with a corporate designee. Say, here are the things that we're going to address with you. And so it's clear that if she's going to testify about those things, there are certain records that she would have looked at. And even in the deposition, it was clear that she looked at those records. And Carmen at trial really did a very effective cross-examination of her, kind of leading up to this moment that she's going to talk about the baseline oxygen. And Carmen asked her that question, say, all right, so you'd agree then that her baseline was 97% on room air. And there was a pause that could have been 2 or 3 seconds, but to us felt like 2.5 hours, where she's thinking about how she's going to play this. And I think, that pause in and of itself was very indicative of her credibility. And I think from there, it was shot. But Carmen did a very effective job of leading up to that. And then once she changes her testimony, discrediting her from there. So I think it worked both in terms of what she should have been prepared for during her deposition, them trying to say, oh, she wasn't actually prepared for that, and then Carmen laying the foundation for that testimony. I thought it all kind of played really well.
So Carmen and Ben, Dorothy doing us a solid, jumping on this while she's away, having a little bit of tech issues, but she wanted you guys to talk about, sort of a juxtaposition of how you use different witnesses. So can you kind of walk us through what you did and how that played out with the jury?
Yeah, so there were a couple nurses that saw Darlene before she was discharged, and she had her oxygen levels taken throughout the time that she was in the PACU and in the hospital. And so we called 2 of those nurses at trial to testify about, their assessments of her and what her baseline oxygen saturation was. And they gave testimony that clearly stated what the policy was and that this policy was violated. One of the nurses went as far as saying that she wasn't trained on the policy, she didn't know the policy, but in reviewing the policy, it reiterates the standard of care, and therefore the standard of care was violated in this case. A nurse testified to that on the stand. And then after that is when we called the corporate designee, and immediately following that testimony where the jury hears that the policy was violated, the standard of care was violated, you get a corporate designee whose title was essentially head of the PACU, responsible for nurses in the PACU, responsible for implementing these policies. And she gets up and testifies that actually the policy was not violated. So I think the way that worked was effective.
And if I could add one thing to that, I thought this was pretty good. We're going through the corporate rep's testimony, and she says that they do nothing to ensure that these policies are followed until after something happens, like someone dies. So she had a moment of honesty.
Was that new testimony that kind of came out during the course of trial? I can't imagine she had said that in her depo, right?
It was new testimony, and I learned that it was time for me to sit down and shut up at that point.
Hey, good for you, man. That's a great lesson for all upcoming trial lawyers. Is you may have a plan of everything you want to cover, but if you get a killer statement like that, you just let it sit and then you sit down, because it's just that impression. It's what you want that jury left with about that person rather than watering it down with like, okay, now let's move on to my next chapter of cross-exam. So good for you for having that sense. What about the defense experts? It sounds like it sounds like this is one of those cases where you guys are just kind of rolling. You got the momentum. Things have just been going your way. And, you're always worried about what somebody may say, but sounds like, you guys kind of had it at that point. But, anything come up with the defense experts you're worried about, or areas you had to cross them on of concern, or, things that they were doing to try to save the day?
Well, this was the one area that Dorothy can say that she did take part in the trial. There was a defense expert that was their video was taken for use at trial, and Dorothy did take the defendant's deposition. So we kind of knew going in some of the major defenses that we were going to hear, at least from one of their experts. Coming into trial, we anticipated hearing from a couple other experts. Now, the expert that we did have a video of touched on the nursing standard of care, touched on the pulmonology standard of care, and touched on the anesthesia standard of care, because the defendant doctors were both a pulmonologist and an anesthesiologist. So while he touched on all of that, we were still anticipating hearing from a defendant expert anesthesiologist. And then 2 weeks before trial, I don't even think, maybe less than that, we got a new report from, I forget the exact subject of which he said he was an expert in. Aging, what was it? Anti-aging.
Board certified in anti-aging medicine from Newport Beach,
so
California.
We got his report. Right, we got his report a couple weeks before trial, and he was attacking her life expectancy. So going in, we were anticipating hearing from an expert anesthesiologist and potentially an anti-aging expert, but as trial progressed, we did not get to hear from either of them. So their sole expert was a pulmonologist, who they used the video that was taken prior to trial.
And that was it. And Dorothy, you did that cross-exam.
Yes, I did that one. Yep.
So, well, good. So Dorothy was right in the mix of this whole thing. She did
Exactly.
the cross of the only defense expert. So,
Right.
that's fair.
Ate this guy's lunch. She just beat him up for like 45 minutes, one thing after the next. Really impacted his credibility.
Well, you guys must have been feeling great about that. Your case in chief, and then the cross exams of the different defense witnesses have gone so good, and the only defense expert, you already know what happened during that. So, you had to be feeling fantastic at that point.
Yeah, we were anticipating the anesthesiologist. They told us, the day that he was supposed to testify, that he wasn't going to be.
Yeah.
Knowing kind of the landscape was helpful.
Why do you think I heard that, I remember in the motion limine argument, it sounded like whether it was just on the bizarre qualification, or you guys also had a lot of fodder on the anti-aging expert, that you probably had a lot on that person. But why do you think they didn't call the anesthesiology expert, given how things were going?
His report, he wasn't necessarily on the same page as the rest of the co-defendants. So I think within his report, he was a little bit critical of the other providers without flat out saying it. But I think he acknowledged in his report that she deteriorated over time while she was there. And their whole defense for the anesthesiologist was none of the nurses told the anesthesiologist that this patient was deteriorating. So blame the nurses. So they didn't want to call this guy.
Further worsen their situation. Got it.
Right.
So, you're going into closing, and I know, you guys kind of have a thing, it seems, going. Ben does the opening and Carmen does the closing. So, Carmen, what did, as you're sitting there beforehand, putting your thoughts together, what you want to focus on, talked earlier about, going through the 12 to 14 defenses or insinuations that the defense had made. What was your goal of closing, and what did you really, focus on as you look back on it?
You know what? I think I said this on the last podcast. I wanted to focus on three things: context, credibility, and common sense. So I wanted to put all the nonsense that the defense suggested into its proper context. In doing so, I knew that would impact their credibility while helping ours. And I wanted the jury to use common sense. Nobody should go into the hospital for a routine bronchoscopy and die that night. So one thing I thought that was good at the beginning, they're talking about these policies as being optional and being just suggestions. And the started to close just by saying, look, patient safety, that's not optional. It's not a suggestion, it's a requirement. That's what the standard is. I focused on because essentially there were two competing standards of care here. The defense standard of care was clinical judgment, which we all know what that means. So their standard's clinical judgment. Our standard is the policies. The hospital's policies were good policies, and that's the standard when they're followed. So, one standard of care that the defense is suggesting, that standard of care only helps doctors in a courtroom after they've committed malpractice. The other standard of care that we're suggesting here helps patients. So it's a no-brainer. So just framing it in that way. And the way that the case came in and the way it was defended, not every case allows you to get indignant in your closing argument. The facts of this case did allow me to get a little bit indignant. But I just wanted to paint the ridiculousness of this whole thing. Like, you hear from all these witnesses, they say one thing at their deposition, they come to trial, they testify the exact opposite. Who here is shooting you straight and who's not? So just in focusing heavily on liability, just super, super important. Now, 95% of the closing was liability. The damage part of the closing, I wanted the jury to feel what Steve felt while obviously not violating the golden rule. So I forget how I phrased it. I said something like, what an experience this must have been for Steve. What an experience that must have been to come in here and see that nobody will take accountability for what happened and see people changing testimony. And I kind of just laundry listed everything that came up during trial and said what that must have been like for Steve to hear that. Obviously folded in the autopsy photo. What an experience that must have been for Steve. And then I like using the jury instructions. One of the elements of his damages would have been, the mental anguish. So I think that when I said what this must have been like for Steve, that all goes to his mental anguish. What it's like for Steve to explain to his young daughters that their grandmother's not going to take them shopping anymore and, paint their nails and teach them to dance and listen to music. So just putting it through that lens, I thought helped. I didn't go too long. I went maybe 45 minutes to an hour. I could have gone 3 hours, but I think by that point, they either got it or they didn't. And I wanted to motivate the jury. I want to empower them. I want them to feel good about their verdict. I want them to want things to be safer for other people. I want them to get pissed off by this bad medical care and the fact that nobody will take accountability for it. So, just focusing on those three things, context, credibility, and common sense, I think that's sort of the framework that I like to work through a closing.
I think it's a great framework. Do you literally say that to the jury? Like, this case is about context, credibility, common sense. I mean, is that actually like you verbally say that to them in your closing?
I did. I said that right up front. I told them, I started with, because I can't help it, I started with chasing down some of the things that the defendant said in their closing. But only
I think that's great. Yeah.
Key things. And I tell the jury, look, I'm not going to chase it all down, but here's 3 things I just heard that are just insane. Got that out of the way. Then I hit my rules, patient safety is not optional. It's not a suggestion. It's the standard. And then I said right after that, this case boils down to 3 things: context, credibility, and common sense.
I think that's great. I think that's a really cool framework that probably a lot of people can use. And then you weave in jury instructions. I think the jury slip typically is very helpful to walk them through to show them the job that they have to do. So very cool. So tell me, how did was it a long deliberation? I'm guessing not too long. They're probably just sitting thinking how much money to give. But I mean, how did that play out?
I wish it was that simple. I think the jury went out maybe around lunchtime.
Oh, wait, this was a while, because I remember Carmen seeing you on the street and they were still out.
That's right.
Oh, that's right. Sorry to make. Yeah, that's right.
I think it was a total, it went through. It was a very inquisitive jury. They asked a lot of questions. I think they went out around lunchtime on Thursday. And then after a series of questions, I think the last question came in around 4:30 p.m. on Thursday. And I think it was it was two questions. It was, how long do we have to stay? The second one was, can we leave? So they came back on Friday, deliberated for another couple hours. So I think it was a total of maybe 7 or 8 hour deliberation.
Yeah, that's rough. But how did the verdict break down?
So it was a total of $5.25 million. $5 million went to wrongful death and $250 to survival.
And in talking with people, did you get any sense of how they thought through the damages and why those numbers at all?
We did talk to the jury after. And so they found against the hospital. They did not find against the two doctors, the pulmonologist and the anesthesiologist. There was one juror in particular who just hated the pulmonologist. And the pulmonologist, got impeached a lot during trial, but he was so likable on his direct. Even when I was crossing him, I was like, I like this guy. He's lying, but I like him nonetheless. And there was one juror who just hated him. And back there, they're deliberating, and, this juror who was very outspoken, he really, really wanted them to find this doctor negligent. Everyone else said no, and he told them, okay, well, in exchange, we're giving his family a bunch of money. If we're not going to find this guy negligent, we're at least going to hit the hospital. And he had a loud voice, a big presence back there. He was a smart guy. He got it. And he was who kind of carried the day back there.
That's fascinating.
And I think and as you know, when you have a systems case, it always helps drive the verdict. It's easier for jurors to hit the hospital than it is for individual doctors. And in this case, it was, you have a clear policy violation. You have people who don't even know the policy exists. And you have the corporate designee on the stand testifying that she doesn't really do anything to make sure that these policies are followed. So in terms of making it a systems case, they kind of did it for us. And I think that helped drive the verdict. It was easier for them to get upset with the hospital than maybe a couple doctors who might not have been given the information that they should have been, even though they should have been doing some other stuff on the side. But, I think that helped.
Yeah, I mean, it's so Greg and I are actually giving a CLE tomorrow at the PAJ convention about how to win individual doctor cases. And because we've all come to realize that the corporate side cases are so much more formidable just from that dynamic of, people, if they can avoid it, they don't want to have to pin something on a doctor who, whatever they did in this particular case, generally speaking, is trying to do the right thing. They're trying to help and care for people. And then here you have this case where, you have two doctors, one of whom's getting impeached over and over again, very incredible. But just by how well they come off, a lot of the jurors still don't even want to hold that person responsible. I mean, not to mention, they're sort of probably like the most important people that could have prevented this in a way. And yet, between those two options, we'll just put it on the hospital, which I think, again, just underscores what we kind of already knew, that the system's corporate case is, whether it's an easier or just a more formidable path to victory, just kind of proves that point once again. But that's a great outcome for all of you. A great team effort. A bunch of three, young superstars. You guys are really inspiring the way that you all put this together, and real teamwork. Dorothy works it up. Then she's got the conflict. Teammates come up, step up. Knock it out of the park at trial. So, and we didn't really get into it, and we don't need to, but I know in the background, there were some serious settlement discussions. And I think the other thing is that, you guys, your client, obviously that plays a big role in it, but that all of you were able to kind of stay the course and, see the verdict to the verdict. There's a lot to be said for that. It takes a lot of guts, and kudos to all of you. Before we close out here, is there, anything else, whether it's to, young up and coming aspiring trial lawyers or law school kids that, maybe one day, they can be doing this, that, I don't know, just advice generally that you can give anybody about how you've approached this. I know you guys are all young, but you've been doing this a long time. You've been working hard at your practice, and you're really starting to see the results. I mean, what can you tell people that are just starting out that would like to get to where you guys are? Your tips on what they should be thinking about and how to apply themselves to get to where you guys are.
Well, I guess from my standpoint, to echo kind of what you said, Brendan, it's to do it, to get into the courtroom, to whether it's through motions, whether it's to get one witness during trial. You can take as many classes and CLEs as you want, but there is no substitute for doing it. And so I don't know if this goes more towards the older lawyers or the younger lawyers, but the most I've learned in trial work and doing this is by being in the courtroom and doing trials. I think I've been in a fortunate situation where I've been permitted and allowed and exposed to trials and participating in trials early on in my career. And I think that is what really gave me the confidence and ability to do this, to go into a case in which I didn't work up any of it. So I think confidence is huge in this, and to have confidence that comes from experience. So as much as any young lawyer can get into a courtroom, can take depositions, can even argue motions in limine, every bit counts. So it's just to get out there as much as possible.
Two real big pieces of advice: go to a firm that gives you the opportunity to try cases. Go to a firm that does try cases. Brendan, you guys are a firm that tries a bunch of cases. We try a bunch of cases over here, and that's how you get better at it. I think the most important piece of advice I would give to a younger attorney or someone getting new into practice: be yourself in front of a jury. Wear it on your sleeve. Connect with people. Don't go in there and try to be a lawyer. You're talking to 12 people from all different walks of life. Be yourself. If you're emotional, be emotional. If you're, if you're not, don't be. Jurors sniff out BS, but if they think that they connect with you and relate to you more than the other side, I think you're going to be better off on the credibility front. But don't be afraid to be yourself in a courtroom. That's the biggest thing.
And Dorothy, let's see if you speak softly, if we can avoid the tech issues.
Not sure about my audio, but honestly, I was going to reiterate what Carmen said. Something I've learned from Carmen, just being at our office, 6 months, 8 months, is that the way Carmen talks to us in the office is how he talks to the jurors at trial. And and you can see that. You can see that he's he's genuine. And so I think that's a takeaway that I have learned from Carmen and Ben. Just be yourself. Don't try to be somebody else, because, other people can see through that. So I agree wholeheartedly.
Awesome. Love it. Well, again, congrats to the three of you. Great to get to do this again so soon with Carmen and Ben and Dorothy. Just really awesome because I've known of you and known you for so long now, and it's just awesome to see you as part of this killer team, and to really put this whole case together to get a great outcome for a worthy family. So congrats all of you, and once again, I won't be surprised if we do it again soon. I hope we will. And just wish you guys all the best. And thanks, everybody, for listening to another episode.
Thanks, Brandon.
Thank you.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.